they want it shut. Is it usually shut?
All rise. Court call, please report the county now back in session. I'm Attorney Howard presiding. You may be seated.
All right, this is the State of Ohio versus Gurpreet Singh, case number CR 2019-07-1095. Present our counsel for the state, along with Detective Flick, counsel for the defendant, along with Mr. Singh. Our interpreters are present, our court reporter, Ms. Fitch is present as well, and this hearing is being conducted outside the presence of the jury. The court took the arguments of counsel in regard to this very serious issue concerning the allegations that had been made that one of our jurors was not following the instructions of law. And I took some time to review notes that I had made last night, early this morning, reviewed some case law. And what this involves is two notes that the court received yesterday evening about 8 o'clock from the jury. One expressing a concern that a juror was not following the court's instructions and rules. And the second one was about conflict in the jury room and that a certain juror felt unsafe as the deliberations continued because of that confrontation in the jury room. And obviously the court is concerned when it is alleged that a member of the jury is not following the law. Upon being informed that a juror was not following the law, the court had a duty to investigate that allegation. The best way in the court's mind to do that was to interview the entire jury regarding the allegations made by one of the members of the panel. Any such inquiry of a juror after deliberations have begun cannot be taken lightly. It must be undertaken after careful deliberation by the trial court and counsel. Obviously, doing so infringes upon the secrecy of the jury's deliberations. So the court made the decision to individually voir dire each of the jurors in chambers with the court reporter present and one member of the prosecution and one member of the defense. Counsel were not permitted to ask any questions of the jurors. All 12 members of this jury have not been refusing to deliberate, specifically the one that is alleged to not be following the law. All of the jurors have had the opportunity to discuss the case, the witnesses, the testimony, and the evidence presented. They have each been able to present their views on the evidence. They have had the opportunity over 14 plus hours to communicate with each other. Has there been some tension in that jury room? No doubt. It has been confrontational at times and emotional. It is abundantly clear to this court that all members of this jury are taking this case very seriously with the goal to arrive at a just verdict. I do not find that there has been any juror misconduct. Has one juror been rude and made snide and derogatory comments to a fellow member of the panel? Yes, they have. But whatever the conflict is, most have indicated that it has not interfered with the jury's ability to deliberate. The juror that feels unsafe or felt unsafe, upon further inquiry, felt that she was being verbally attacked, which was supported by several of the other members of the jury. Earlier in the day, after being informed that the jury may not be able to unanimously agree on a verdict, the court brought the jury in and gave them the Howard charge, and the foreperson unequivocally stated that further deliberations may be fruitful. However, after another 3 hours, the allegation was made that one juror was not following the law. Jurors are instructed that it is their sworn duty to accept the instructions provided by the court and to apply the law as it is given to them. They are not permitted to change the law, nor to apply their own conception of what they think the law should be. They are instructed, as it relates to witnesses, that it is their province to determine what testimony is worthy of belief and what testimony is not worthy of belief. It is their duty to carefully weigh the evidence, to decide all the disputed questions of fact, to apply the instructions according to their findings, and to render their verdict accordingly. In fulfilling that duty, their efforts must be to arrive at a just verdict. It does not require that a verdict be reached in every single case. They are instructed to consult with one another, consider each other's views, and deliberate with the objective of reaching an agreement if they can do so without disturbing their individual judgment. Each juror must decide this case for themselves, but should do so only after a discussion and consideration of the case with their fellow jurors. They are instructed to not hesitate to change an opinion if they find that it is wrong, but should also not surrender honest convictions in order to be congenial or to reach a verdict solely because of the opinion of other jurors. Not every juror agreed with the allegation that the one juror was not following the law. The juror in question denied the allegation. The court finds that the juror number 83, was following the law. That juror, in deciding the case for themselves, refused to surrender honest convictions in order to be congenial or to reach a verdict solely because of the opinion of other jurors. While the objective of any jury trial, much less a capital case, is to reach an agreement, such must be done only if it can be done without disturbing any one juror's individual judgment. A trial judge is empowered to exercise sound discretion to remove a juror and replace him or her with an alternate juror whenever facts are presented which convince the trial judge that the juror's ability to perform his or her duty is impaired. Not agreeing with everyone's views on the evidence does not mean that a juror's ability to perform their duty is impaired. A jury verdict must reflect the verdict of each individual juror and not mere acquiescence in the conclusion of other jurors. I do not find that juror number 83 was dishonest in voir dire or was disruptive to the deliberations to the point that deliberations cannot continue. I find that the juror in question has reached a verdict after careful consultation with her fellow jurors, but that verdict is contrary to that reached by the other jurors. So I'm denying the motion to remove both 111 and 83. I'm denying the motion for the mistrial as well. My intention, and I did this on my own, and I know the state made this proposal, but it's something that I was going to do on my own, just so everyone is clear. I'm going to bring these jurors back in here, make sure that they have followed the court's instructions and that they have not been subject to any outside influence. I'm going to ask them, or direct them, to return to the jury room. I am going to give to the bailiff a note to be handed to the foreperson that has a case caption on it, today's date, and 2 lines with a space next to it to be checked. The first one is, we would like to continue with our deliberations. And the second is, we do not believe that any further deliberations will serve a useful purpose. I am going to suggest to them that maybe they consider electing a new foreperson in regard to this matter to see if that may help or assist in regard to their deliberations. It is my and everyone else's desire in this room that this case reach a conclusion with this juror. And I'm going to give them the opportunity to do that if they believe that they can do that. So we're going to bring them back in. I'm going to inquire as to what happened over the evening hours. I am going to direct that they return to the jury room. We will give them this note, and depending on the response to the note, it will depend on what happens next. All right? Mr. Blankenship, should bring our jury in, please.
You want them?
It wasn't requested by the jurors.
All right, ladies and gentlemen, you may be seated. It remained on the record, and let the record reflect that all 12 members of our jurors are present. Good morning, ladies and gentlemen. I apologize for the delay, but as you all know, we broke last night. The court had to take into consideration a very serious matter in regard to this trial, and that's what we've been doing this morning. Did everyone follow the court's instructions last night concerning your conduct, your behavior, not permit the case to be discussed with you or in your presence? Have any of you been subjected to any outside influence in regard to this matter during the period of time that you have been outside this courtroom or the jury room? All right. Ladies and gentlemen, I'm going to ask or direct that you go back into the jury room. I am going to give the bailiff, will hand to you a form that I want you all to consider, and I want the foreperson to respond on this form. One thing you all may want to do as part of your deliberations is consider a new foreperson. If you think that may help in your deliberations. If you don't think it's going to help, then you don't do it. I'm not saying that you have to do that. But the form that I'm going to give you is a very short form. It has 2 lines. The top line is, we would like to continue with our deliberations. The second line is, we do not believe that any further deliberations will serve a useful purpose. So I'm going to ask that you go back into the jury room, have Mr. Blankenship hand this form to the foreperson, discuss this form and the contents of the form, respond accordingly, have a foreperson sign the form, knock on the door, and hand it to Mr. Blankenship once you have discussed the form and reached a decision in regard to the 2 items on the form. All right? And then we'll go from there. Right? Thank you for your patience, ladies and gentlemen. We ask you now retire from the courtroom into the jury room, and I'll have you.